Hello everyone, I'm George from Ireland, so welcome to my English Law channel. This talk is going to be about statutory interpretation. So I'm going to look at the different kinds of statutory interpretation, the rules of language which are used when interpreting statutes, the presumptions which are presumed, other aids which are used when interpreting statute, and lastly, glance at the Human Rights Act 1998. So, parliamentary supremacy, as you might know, is a core principle of the United Kingdom's constitution. So, you might have read an introduction to the study of the Constitution by Albert Venn Dicey, who's famously professor of public law in the University of Oxford in the late 19th century, right up until his death in 1922. And this is what Dicey had to say. The right to make or unmake any law whatsoever, and further, no person or body is recognised by the law of England as having the right to override or set aside the legislation of Parliament. So that was Dicey's definition of parliamentary supremacy, or parliamentary sovereignty, we sometimes say. And it goes further from Bagehot, Walter Bagehot, the 19th century banker and political philosopher, who published his English constitution. Perhaps he ought to have said British constitution, but English was a widely understood synecdoche for things pertaining to the entire United Kingdom. When Bagehot said that Parliament is omnipotent in all things except the power to destroy its own omnipotence. A bit like the people say, how then could the United Kingdom Parliament accede to the European Economic Community, which later became the European Union? Because then the UK had to accept laws from outside the UK, and Parliament had no say in those. Well, people were able to square this circle by saying, yes, but the United Kingdom is only accepting those laws so long as Parliament consents to maintain that situation. Parliament could at any moment revoke its consent and the UK could depart from the European Union, and indeed it came to pass. So an important case on parliamentary sovereignty is British Railways Board against Picken, 1974. Well, one of the rules of statutory interpretation, or one of the methods, is the Mischief Rule, and this came from Hayden's case in 1584, where they asked a number of questions. Was it common law? What was the mischief and the defect? What was the remedy, and what was the true reason for the remedy? So looking at the mischief that law was sent to correct, and then saying, all right, we'll interpret the statute in the light of that, in the light of trying to remedy the mischief. Smith and Hughes, 1960, is an important case about this. It related to Section 1 of the Street Offences Act 1959, where it said, it shall be an offence for a common prostitute to loiter or solicit in a street or public place for the purpose of prostitution. Okay, common prostitute as opposed to what? As opposed to a call girl or a paid mistress? I'm not sure. But anyway, but what if she's standing on a balcony? What if she's standing in her house with the windows open, scantily clad, coquetting, trying to attract punters? So that was found actually not to be a breach of the law, so long as she's actually in her house. And the literal rule is an example found in the Sussex Peerage's case, 1884. And the Chief Justice Lord Tyndall ruled on this, and this is what he said. If the words of the statute are in themselves precise and unambiguous, then no more can be necessary than to expound on the words in their natural and ordinary sense. Close quotation. There was a case where in the 19th century, one man bit off another man's nose in a fight, and he was charged with the Offences Against the Person Act. But the Offences Against the Person Act said, obviously, you're not allowed to kick, punch, slap, hit with a blunt instrument, stab with a sharp implement, throttle, twist somebody's arms. All sorts of things prohibited. But it didn't prohibit biting. And so was this person guilty or not guilty? And they found there was actually no crime of biting somebody, even very badly, even if it draws blood. The person actually died, so that was not guilty. And it went all the way to the House of Lords, and the House of Lords said, it might seem like a ridiculous outcome, but it's not for us to repair. If Parliament can change it, we're not going to imagine something is in the statute which is not there. So anyway, that would be an example of the literal rule. Fisher and Bell, 1961, is another important case, and this is about Section 1 of the Restriction of Offensive Weapons Act 1959, making it a crime to sell, hire, or offer for sale certain weapons unless you've got some license. Okay, so the golden rule, that's another method of statutory interpretation. River Weir Commissioners against Adamson, 1877, is an important case here. It went to the Court of Appeal. And they said sometimes there's inconsistency in the law, there's absurdity, there's inconvenience which arises from sticking too strictly to literalism, so we've got to move away from that. So the Road Traffic Act 1960 said, it shall not be lawful for a person to drive a motor vehicle of any class or description on a road at a greater speed than the speed specified in the first schedule of this Act, as the maximum speed in relation to a vehicle of that class or description, close quotation. That's as per section 24.1. But Schedule 1, paragraph 1 said, vehicles adapted to carry more than 7 passengers, exclusive of a driver, 30 miles per hour, close quotation, as in 7 passengers plus the driver, that'd be 8 people. So in Storer, Maddox against Storer 1962, there was a case about this, and there seemed to be some sort of contradiction of the law. Section 13.1 said, it shall not be lawful for more than one person to be carried on a road on a bicycle not propelled by mechanical power unless they're constructed or adapted for the carriage of more than one person, close quotation, as in tandems are allowed, but if you have an ordinary bike, you can't have somebody sort of standing behind with their feet on those bars that come out from the back wheel, or sitting on your front wheel, something like that. Schedule 1, paragraph 1 said, vehicles adapted to carry more than 7 passengers, exclusive of a driver, well, I read that one. So Chief Justice Parker had to expound on this, and this is what he said. If one gave it a meaning in paragraph 1.1 of the first schedule of being altered so as to make it fit, it seemed to me to make nonsense of the provision, close quotation. So what is the law here? The law can't make up its mind. So there can be a purposive rule, which really absorbs the mischief rule. There's Pepper, Inspector of Taxes against Hart, 1993, when it was ruled by Lord Brown Wilkinson. The purposive rule is to give effect to rather than thwart the intention of Parliament. That's Brown Wilkinson. Other schools of thought said no, that judges shouldn't look into the parliamentary debate and what the context was and what the aim was. No, that would be intruding into the political sphere, and they must both their appointed limits keep, both the judiciary and politicians. So R against Pig 1983 is another key case here, and this relates to section 17.3 of the Juries Act 1974, where it was held, a court shall not accept a majority verdict of guilty unless the foreman of the jury has stated in open court that the number of juries who respectively agreed to and dissented from the verdict, close quotation. So Lord Brandon ruled on that, and he said, it is a substance of the requirement prescribed by section 17.3, which has to be complied with, and the precise form of words by which such compliance is achieved, so long as the effect is clear, is not material, close quotation. Because what exactly does the foreman have to say? He has to say, we had 11 voted guilty, 1 voted not guilty, or something like that. Or what if he said, 1 voted to acquit him, and the rest didn't? Would that be good enough? Would those words be good enough? But anyway, Lord Brandon said that they would, so long as the meaning is understood. It doesn't matter precisely which words he uses. Okay, so there are a number of linguistic presumptions in relation to statutory interpretation. And now a presumption, remember, is not a rule, and it is not precise, okay? So this is where we start off. There could be convincing evidence to the contrary, in which case the presumption will be overcome. It's a prejudice in one direction. This will be the assumption unless demonstrated otherwise. So we can rebut them. They're rebuttable and irrebuttable presumptions in law. These are rebuttable ones. The eustem generis rule, sort of like of their own kind, really, of his own kind, is when 2 or more words are followed by a general clause. The presumption there is that the general clause is limited to things of the same nature as in the list. Often these lists are illustrative and not exhaustive. So we're not going to think of every single thing in this category. There's been an example, going back to that law about assault, Offence Against the Person Act, when it said you can't kick, slap, strangle, throttle, punch, twist limbs, tie up, stab, hit with a blunt instrument. And you might say, well, it didn't actually mention bite, but we'd have to assume that things, other things should be in that list. Anyway, section 2.1 of a certain act was about animals such as sheep, goats, pigs, cows, horses, and other animals. Did that include donkeys? Did that include foxes? Did that include hamsters? They're other animals. All animals? Why not just say all animals in that case? So section 3.1 of another act, supposing it's about plants, about things, it was said parsley, dill, what if it said cabbage, chard, and other plants sold in pots. How about orchids? Does it include them? Quince, tarragon? Which plants are sold in pots? What if I sell it in pots and she doesn't sell it in pots? Is it sold in pots or not? What if only one person in the world sells it in pots? You see, it's rather unclear. Maybe it was what a reasonable man would assume to be in pots. I mean, this reasonable man concept is very slippery. Who's to say it was a reasonable man? It was rather unreasonable, that. Anyway, Eustem Generis, there was Pole against Kempton Park Racecourse, 1899. That racecourse just southwest of London. So this was about Section 1 of the Betting Act, 1853. It said about the betting, it had to take place in a house, office, room, or other place. So why not just say any place? If it's any other place, why would we bother saying house, office, or room? Okay, so there's expressia unius ex clausia alterius, which is as in if you express one thing, you're excluding the others. So if there's a list without a general clause after it, then we presume that if something is not included in the list, then it is excluded from the list. So section 2.1 of a certain act said it's applicable to horses, cows, sheep, pigs, and goats. It didn't mention donkeys, so they are in the list. As they're not on the list, we'd have to say no, they are excluded. So if there's an adjective linked to a noun, then we presume that the adjective has the effect of restricting the meaning, and therefore it's disapplied to things that lack that particular factor. Section 3.1, it is a defence to have written consent, close quotation. So you have to ask, would there be defence if you had spoken consent? Well, as it didn't have a general clause, as it didn't go on, as it's not included in the list, we assume it to be excluded, that oral consent will not operate. Expressia unius est exclusia alterius. Carry on with that. So to express one is to exclude the other. R against inhabitants of Sedgley, 1831. There was a statute from the 43rd year of the reign of Queen Elizabeth I, which said about lands, houses, and coal mines. And they said, well, if it's not in that list, it's excluded. Or, Smith against Hughes, 1960, going back to about the hookers soliciting, trying to attract clients by showing her décolletage or whatever in her window, standing on a balcony, about the offence of loitering in a street or public place. Is your house a public place when it faced onto the street? And the court found that it was not. So another rule here is noscitur ad socius. So to know by its neighbours or by its associates. You're known by the company you keep. So a word takes its signification from the other words in that clause with it. So Section 20 of the Wills Act 1837 said as a will can be revoked by burning, tearing, mutilating, or defacing. So what if you burn it, but it's not completely reduced to ash? What if it's only lightly singed? Is that sufficient, or must it be destroyed completely? So a word takes its meaning sometimes from somewhere else. Other bit in the statute might say, for the avoidance of this doubt, this word means blah, blah, blah. Section 2 about written consent. Section 6 about consent. So is spoken consent sufficient? Well, no, because earlier on said it had to be a written consent. Oral consent will not operate. So another example of noscitur ad socius, as in known by its associates. So R against Harris in 1836. This was a statute from the 9th year of King George IV. And it said, a person who shall unlawfully and maliciously stab, cut, or wound any person, has committed a crime. So this was they had presumed that there is no criminal liability if you lack mens rea, as in the guilty mind. Sweet against Parsley, 1970. And so this is what Lord Reed had to say. whenever a section is silent as to mens rea, there is a presumption that in order to give effect to the will of Parliament, we must read read in words appropriate to mens rea. Close quotation. So here are the presumptions. You presume against changing common law. You presume against taking away a person's liberty. You know, we have permissive liberty. You've got the right to be free, go wherever you want, unless there's a good reason otherwise. Habeas corpus rule. People are not to be sent to prison unless they're proved guilty of a crime. The United Kingdom has occasionally suspended that. Okay, there is a rule against retroactivity, you know, because so here we are today, supposing they said that eating ice cream was illegal even in the past. I ate ice cream yesterday, so I'm in trouble. Well, when I did it, I did it with an innocent mind. I thought it wasn't against a crime. I couldn't have avoided committing a crime. I had no idea the next day it was going to be illegal, and illegal for me to have done that before the law was even passed. There is also a presumption against sequestrating private property. So if they're going to confiscate things from you, the police officers need a very good reason. In wartime, pass the Defence of the Realms Act. So the onus is on those who claim that property should be deprived from people to prove their case. There's a presumption against accruing any advantage or enrichment from wrongdoing. That would include sharp practice as well as things which are actually illegal. And that's per Ray Sigsworth, 1935. There is a presumption against intruding on privacy and taking away a person's rights. And there is a presumption against binding the Crown. So many acts of Parliament says this act shall not bind the Crown. They're exempt from some sort of racial discrimination legislation, for example. There are other aids, intrinsic ones, as in actually in the act itself, the short title, because it might say the Hunting with Dogs Act, and I don't know what the long title is. It might say an act to prevent cruelty to hares, rabbits, and other beasts by them being hunted by canines, something like that. So the short title, the long title, there's the preamble, a few sentences at the beginning saying the purpose of this act is this and this. I mean, by order of the Queen's most excellent Majesty, with the advice and consent of her Lord Spiritual and Temporal, and the House of Commons in Parliament assembled, or something like that, and then go on to say why we're doing the act, and then the interpretive section saying, okay, for the avoidance of doubt, in this act, child means a person under the age of 18 years. Yeah. Dog here means Canis Janus, or a cross between a dog and a wolf, or something like that. And there would be extrinsic aids. This will also help people with statutory interpretation. The Interpretation Act, 1978. The dictionary has been referred to in R. against Fulling, 1987, probably the Oxford English Dictionary. Looking at Hansard, which is a transcript of the parliamentary debates, going right back to the late 18th century. Prior to that, the press wasn't even allowed to report parliamentary debates because that would be intrude upon the independence of Parliament. And the Parliament wasn't sound recorded till the 80s and wasn't even filmed to the early 90s. I think it was ridiculous they didn't, and I don't see why courts shouldn't be filmed in the United Kingdom. They're filmed in almost every other jurisdiction. I don't think it diminishes justice there. So Pepper and Hart, 1993, is a case that actually looked at the transcript of the parliamentary debate, as in what was discussed, what was wanted. But obviously, you only need to win by one. 326 votes in Parliament would be enough to pass it in the Commons. You might have everybody else against, so some things are passed by a massive majority. Look also at European law. So the Human Rights Act 1998 is important, and Section 3 says, so far as it is possible to do so, primary and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights, close quotation. Convention rights meaning rights found in the European Convention on Human Rights. Now, remember it said insofar as it's possible to do so. Sometimes it's not possible to do so, in which case a court will issue a declaration of incompatibility. The courts won't nullify the legislation. They will leave it up to Parliament to amend or not. Now, coming back to the Human Rights Act, Section 4.2 says, if a court is satisfied that provision is incompatible with the Convention right, it may issue a declaration of incompatibility. There, close quotation. Note it is actually not obliged to. It says may, has the right, has permission to do so. But the trouble is in English, may can sometimes it means has permission to, sometimes means has ability to. Obviously the two overlap. The only time that a court has nullified legislation is to do with the marital rape case in 1991, when there was a presumption that a wife had irrevocably consented to intercourse when she married. She promised to love, honour and obey her spouse. And so House of Lords struck that down, said no, rape can occur within marriage. So that was a key moment, and they said because it's just unthinkable that Parliament will seek to overturn this, and indeed did not, and so far as I know, no one objects. So what conclusions can we reach at this stage? So the rules are there in order to assist judges in applying legislation to the cases before them. And there is no right answer to which method of interpretation ought to be used. The golden rule, the mischief rule, the literal rule. They are. This is about the application of the rules rather than simply learning them off by heart and trotting out a definition of those three rules. So that's just a little bit about statutory interpretation. Make sure you subscribe. Please donate to me on PayPal, georgecallahan79@gmail.com. That's all small letters. Callahan spelled Callaghan. I teach law and all sorts of other subjects online. So contact me. Toodaloo.